staff indicated that. You can argue with me all you want, Ms. Tobe. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
That is not,
it was delayed.
Not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond.
Hold on to your seats, because this courtroom drama is absolutely insane. Former attorney Donna Tobe is in hot water for filing pleadings without her client's knowledge, triggering bench warrants, exorbitant cash bonds, and a whirlwind of procedural chaos. We're breaking down every shocking twist, showing why these mistakes have massive consequences, and asking, was this fair or completely over the top?
The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14th, 2026, 9 a.m. Thank you. Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Yes.
Good.
State your name.
Donna Tope, I'm appearing on behalf of myself.
Ms. Tope, I had issued a bench warrant for your arrest for failure you to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt and the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and or other cases. And therefore, I would like to have this on the record.
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video, A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling. I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time, so I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Wiedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion, affidavit, and order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2, page 1, states, I am being held by the judge in contempt for filing a pleading without my client's knowledge, nor being the attorney of record. At number 3 on page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed, which is 6 days shy of the required 14-day notice by mail. The facts are that I was not properly served nor properly noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order and the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that Brandon Davis, no response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls case of People versus Theodore Edwards.
David I. Goldstein. Theodore Edwards. We have a plea worked out in this matter, Your Honor. Mr. Cook is going to add a count of
Do I have
the advice of rights.
Have the advice of rights to have a plea form.
Oh, no, sorry.
I'll pass it. Please. Court calls case of the People versus Michael Elkins.
People. For the judge. Court shall feature assistant public defender on behalf of Mr. Elkins, who I hope is present.
Yes, Your Honor.
State your name.
Michael Elkins.
Thank you.
Thank you.
What are we doing?
Thank you, Judge. Looks like Mr. Elkins' license was still suspended last week, and he's still trying to get that resolved. The adjourned or set it for final settlement conference, whichever the court's pleasure is, Your Honor.
April 15th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Sincere Godwin.
Your Honor, ring of the people.
Ron Brown appearing on behalf of Mr. Godwin.
Sincere Godwin. Oh, yeah. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. Give a 10% privilege. That warrant will issue immediately. Court calls case of the People versus Tony Gomez.
Your Honor, ring for the people.
Ron Brown appearing on behalf of Tony Gomez.
Tony Gomez.
Your Honor,
Yes.
we're in the process of having him evaluated for the Veterans Court in Dearborn. I've been in contact with him as of yesterday. I'm requesting an adjournment so that we can complete the process. My colleague did submit, I believe, a MOU in November. Ms. Perrine.
I don't know, but we don't know where he is.
Your Honor, he is not in custody, but I've spoken to him all Friday, Monday, Tuesday.
Well, I'm going to issue a bench warrant. Around $7,500, 10%. That warrant will issue the 20th. Okay. Court calls case of People versus Joseph Hamby.
Ron Brown appearing on behalf of Mr. Hamby, Your Honor.
State your name, sir.
Joseph Hamby.
What are we doing?
I'm requesting an adjournment, Your Honor. April 15th.
Why?
My information is the vehicle in question is not drivable. I'm trying to obtain verification of either transfer of title or scrap title so that there's no vehicle, proof we have no vehicle in the household.
April 15th, 9 a.m. Fine, continue. Court does call the case People versus Wilmer Hudson.
Morning, Your Honor, ring for the people.
Ron Brown appearing on behalf. State your name, sir.
Wilmer Hudson.
I have a plea form indicating that he's going to plead to attempted resisting and obstructing a 1-year offense upon a successful plea to, well, this form isn't filled out correct. Well, is this charged as an attempt?
Yes, it is. Yes, it is.
So he's pleading as charged to attempted resisting and obstructing. And then there's a prosecutor who will recommend no upfront jail. That's the court's full understanding.
That is correct, Your Honor.
Yes, sure.
That will flow.
Raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but so help you God? State your name, please.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yeah.
Still wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You've signed an advice of rights form, is that correct?
Yes.
Question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
Now things get really explosive. Tobe received notice of her hearing only 6 days before the court date, way short of the required 14 days. That led to her being held in contempt and slapped with a $10,000 cash bail. And it gets crazier. The YouTube recording of the bench warrant has been used in other cases against her. Audience, tell me, how fair is it to face punishment when notice was improperly served? Could this happen to anyone in your state?
May 5th, 2025, at the location of Ellsworth at Stone School Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you come into contact with officers from Pittsfield Department of Public Safety?
Yes.
What happened?
Well,
Did they order you to pull over and exit your vehicle?
yes.
And did you refuse their lawful commands to pull over and exit your vehicle?
Yes.
All right.
And they were in uniform and you knew they were Pittsfield police officers?
Yes.
All right. Sir, I do have to advise you if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
9th at 12 noon.
April 29th, 2026, 12 noon.
I'd ask bond continue.
Continued. Court calls the case People versus Austin Ingram.
Your Honor, read for the people.
Court Feaster, Assistant Public Defender, on behalf of Mr. Austin Ingram.
During the plea.
Austin,
Hi.
state your name. Say your name, please.
Austin Ingram.
Thank you, Judge. I did speak to Mr. Ingram and father yesterday. I believe they're requesting this matter be set for final settlement conference and jury trial, Your Honor.
Jury final settlement conference in this matter, April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Bond with its conditions will continue. Thank you.
Thank you, Judge.
Court does call the case People versus Devon Foster.
Raymond Cook for the people.
Judge Torshell Feaster, Assistant Public Defender, appearing on behalf of Mr. Javon Foster. Please state your name for the record.
Devon Foster.
Thank you, Judge. It looks like he was recently arraigned. I believe we'll be asking for an adjournment to speak to Mr. Foster and see what possible resolutions there are.
During the matter, April 1st, 2026, 9 a.m. Bond continues.
Thank you, Judge. You got a comment?
Yes. Court recalls the case of the People versus Theodore Edwards.
Morning, Your Honor, Raymond Cook for the people.
Doug Goldstein is bringing on behalf of the defendant.
Theodore Edwards.
Now, Your Honor, we have reached a plea agreement. He's going to plead guilty to an added count of retail fraud third and make restitution. In exchange, the people are dismissing the original charge.
So, he's agreeing, the defendant's agreeing that he'll pay restitution.
Yes, Your Honor.
Your Honor, for what it's worth, I don't believe there will be any restitution owed on this case. My understanding is
Okay, but if there is any, obviously the agreement is he will pay rent.
And I just added that to the form. He agrees to pay restitution if any. And that's the court's full understanding of the agreement. Is that correct?
Correct, Your Honor.
Kevin Swan.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. State your name, please.
Theodore Edwards. Sir, it is this court's understanding that you are going to be pleading guilty to the charge retail fraud third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
You wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yep.
You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
Misdemeanor.
He wasn't at the time of this offense, Your Honor. He is now.
Has anybody promised you anything other than what's
No.
stated here today on the record to get you to plead? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Absolutely.
of your own free will
Yes, sir.
and because you believe that you're indeed guilty of this offense?
Correct.
On the date of July 21st, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Target store that makes you guilty?
I had some items that wasn't purchased.
Okay, so you went into the store,
Yes.
picked up some items and tried to walk out without paying for them?
Yes, sir.
All right. And the store was open to the public at the time?
Excuse me?
The store was open to the public at
Correct.
You didn't have anybody's permission to take that property, did you?
No, sir.
And the property that you took was property that Target had offered for sale?
Absolutely.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court has to advise you that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Correct.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant's referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2006.
29th, Your Honor, that's fine.
Yes, 12 noon.
9, I'm sorry,
Bond will continue.
9 o'clock,
Noon.
noon.
All right, sir, make sure to stop down at my probation department about halfway down the hallway.
Okay.
All right, on the left-hand side.
All right.
May I approach for a moment, Your Honor?
Okay. Well, that was fun. Court does call the case of the people versus Albert Wilson.
Swearing in your agreement close to the people.
You don't look over your head and tell it, John. Appreciate the brief adjournment, court permitted to discuss this. With Wilson, he has read the advice of rights form that was tendered to him. He's re-signed it. It's, put your ears up. Yeah, okay, good.
Can you hear me?
Yes.
All right.
And he has signed it, so I'm sure that he's familiar with it, Your Honor.
All right.
We've also
Are you
signed.
signed and gone through that advice of rights form, sir?
Yes, I did.
Any questions regarding any of those rights?
No.
All right, look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, he said that.
All right. You understand that you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, signed it.
Has anybody promised you anything other than what's been stated here today,
File.
which is nothing? get you to plead to this case?
No.
Anybody threatened you or coerced? You're doing this voluntarily and of your own free will?
Yes, I am.
Your Honor, I might amend that if I might. We have an agreement with the prosecutor that the prosecutor is going to recommend community service. And if the court doesn't give him community service at the time, then he has the right to withdraw. That's the only.
I am not. You guys can agree to. I am not agreeing to.
I understand that, Your Honor.
And to make it clear, the plea form that I believe was handed over says that the people are recommending the community service instead of jail. I understand that the court is not bound by that, but that's what the people will be recommending.
Yes, Your Honor. The other thing we would request is in discussions with the prosecutor, Mr. Wilson has had, as I think the court is aware, has had some difficulty, justifiably or not, with the testing of required by the.
Now things get really explosive. Tobe received notice of her hearing only 6 days before the court date, way short of the required 14 days. That led to her being held in contempt and slapped with a $10,000 cash bail. And it gets crazier. The YouTube recording of the bench warrant has been used in other cases against her. Audience, tell me, how fair is it to face punishment when notice was improperly served? Could this happen to anyone in your state?